but let's begin with Whitney. As you said, it's considered a dissent, even though it was technically a concurrence. I'm just going to read a few of its beautiful words because it's so inspiring. Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. And that, you say, was almost a direct quotation from Pericles' funeral oration as translated by Alfred Zimmern in the book that Brandeis valued more than any, The Greek Commonwealth. Why is the Whitney decision, by many accounts, the greatest statement of free speech ever, and what made it so prescient in its time?
Okay, you have to give me a moment to go back in history here. All of you know that modern free speech jurisprudence really begins with Holmes's dissent in Abrams, in which he uses the market of ideas analogy. But there's a problem with it. It's a wonderful phrase for a philosopher, which Holmes always saw himself as, okay? It's not a very good guide to lower court judges. Remember, the Supreme Court, one of its functions is to provide guidance to lower court judges when they, cases come up. What Brandeis does in Whitney is he shows why the First Amendment is important to a democracy. Not to a philosopher, but to a democracy. He always said that the highest office that anyone could hold in a democracy was that of citizen. But being a citizen meant you had responsibilities. You were supposed to take part in the dialogue over public policy. You do this a number of ways: by the candidate you vote for, by going to town hall meetings, writing letters to the editors, all these sort of things which are fairly common. But if you are going to make an intelligent decision about public policy, then you have to hear all the points of view. That's what he's saying in Whitney. We can't shut people up. They have to hear, the citizen has to hear not only what he already agrees with, but opposite points of view, so that he can then make an informed decision. Holmes later on, after this case, will, as you recall, make the memorable statement that the First Amendment is not for speech we agree with, but for speech that we hate. And Brandeis really is leading into this. You have to be able to know all the different views. And his view was that the citizenry is smart enough to dump the wrong views, the erratic views, the ones that are undemocratic. We could then go into a riff on the current Republican nominees, but we're not going to go that way.
On a nonpartisan basis.
Nonpartisan basis, right.
Let's stick to Brandeis, sir. As you describe it,
I can do that on a nonpartisan basis.
That's fine. No, Brandeis is making an argument about the importance of free speech on a nonpartisan basis, yes, because he is talking about the value of dissent. He's saying unless citizens have access to the best arguments on both sides of a question, right, they cannot educate themselves and make themselves ready for the duties of democracy. That's why he says that the best response to bad speech is counter speech, and that's why he comes up with the most speech protective test in the history of all time, although Madison and Jefferson in the Virginia and Kentucky resolutions had a vision of it as well, where he says that speech can only be banned if it's intended to and likely to create imminent violence. That extraordinary principle, not shared by any European democracy today, became, as Mel said, enshrined in the American Constitution when the Supreme Court accepted it in the 60s. Yeah. But I'm going to read, you can't read too much Brandeis. And the whole theory of American government and of counter speech and of the value of dissent is found in the rest of this paragraph. He says, they believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech and assembly, discussion would be futile, and that with them, Discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. That's constitutional poetry. How did he build? He starts so technically, he starts with the facts, and then he's expanding slowly, and then reaches this extraordinary crescendo. Why was he so good?
This is what makes, I think, a great dissent in one way. Brandeis here is laying down principles eloquently. By the way, no, he was not known for his eloquence. He was not a Holmes in terms of stylist. One of his clerks said that Brandeis's letters to his wife read like Brandeis briefs, point 1, point 2, point 3.
No. You quote them. He had some very tender letters. He talked
does
about buying
have
some flannelettes of dazzling beauty, his pajamas. He was joking to his wife.
In most of his opinions, no, those he writes for the majority, he says, I'm not speaking for myself. I'm speaking, for a majority of the court. They're relatively short. They're concise. They're not poetic. But when he speaks for himself, and he was a great fan of Periclean Greece, his prose just soars. I think it does the same thing in the Olmsted case. Which is one of my favorite cases. I've always said that the story of Roy Olmsted ought to be a case study at the Harvard Business School. This is a guy who was a policeman out in Seattle during Prohibition times. And he looks around, he says, there's money to be made selling liquor, but the people around here aren't doing it right. So he leaves the police force, sets up with 10 other guys, they each throw in some money, and he sets up a business. He brings in good hooch from Canada, rents a farm out on the outside of town with a basement where he can store it. His brother stays on the police force to warn him in case there's going to be a raid. And they set up this downtown office, so if you wanted a case of good bourbon for your party tonight, you pick it up. Roy, when can you have it here? 30 minutes. And not only that, everybody in town loves him. He gives money to all the charities. Everybody knows what he is. Nobody is at all upset except the feds, who then wiretap and use the wiretap to convict him on violation of the Prohibition law. Brandeis is appalled by this. He's been interested in privacy ever since the 1890s. And he said modern technology can destroy privacy. There was something, he had a clipping in the file on the Olmsted case of this new invention that was being tried out in Schenectady, New York by General Electric, something called television. And he wanted to include it in his dissent, but his clerk talked him out of it.
Because he thought it was a two-way technology where he anticipated Skype, basically.
Yeah. The people could, what is said in the closet shall be broadcast from the rooftop, sort of thing. And so there are two things that happen in Olmsted. First of all, he redefines the Fourth Amendment, which finally is accepted by the court in a case called Katz versus United States, I think, in which Potter Stewart says the Fourth Amendment protects people, not places, which is what Brandeis says back in the 20s, when William Howard Taft says, well, they didn't go into the building, so there was no Fourth Amendment violation. But the reason that Holmes writes a separate dissent, a short one, is he couldn't go along with Brandeis on the privacy thing. This is pure Brandeis. It's going to take a long, long time before the court recognizes it. And in fact, there's still some people on the court who don't recognize it. But this is a very, very important decision because it lays down the constitutional basis for a right to privacy.
And he's translating the Constitution in light of new technologies. He says, right, at the time of the framing, a smaller invasion, breaking into someone's house with a general warrant to read his diaries, was considered a violation of the Fourth Amendment. But wiretapping is worse because you can hear the conversations on both ends of the wires. And therefore, although the framers relied on the law of property, we have to anticipate what may be developed in that incredible passage. Ways may someday be developed by which it's possible, without physically intruding into the home, to extract secret papers from drawers and introduce them into court. He really is anticipating the internet and saying that we have to translate the Constitution to protect
the
the
people
framers'
who
values.
write the great dissents, I think I say something, are anticipating a future that they know very little about. They're anticipating where we're going to go. And this is a good example of it. I mean, Brandeis couldn't really guess, internet, things like that. Nobody knew about them. Al Gore hadn't invented it yet. But he's anticipating, based on what he knows, that in the future it's going to be even harder to protect personal privacy. He's anticipating in the speech cases how important it will be to let all viewpoints come through. Hugo Black is anticipating that at some point people will recognize that you can only have a fair trial with a lawyer. Harlan, one, is anticipating a future that no one at that time could see. If somebody had said to Harlan, someday they'll elect a black president, he would have said, nah. But he did believe that you couldn't constitutionally discriminate against any group because of their color. Gender was another story.
Is it, if you were advising, all the justices would like to be prophetic dissenters, who wouldn't? Is there bless you, is there a formula? How do you do it? How do you anticipate the future?
It's an individual genius. I think